Today I want to discuss about a contract. I want to go into detail and then talk about the crucial points that constitute to what a contract is, how a person can contract, who can contract, and I believe by the end of this discussion we will have tackled such questions of who can contract, how people contract, who is eligible. Such questions will be answered. To begin with, a contract is an agreement between two parties, whereby if I mean an agreement between two parties, that means for it to become a contract, these two parties that are intending to contract must agree on the terms and the conditions. In Uganda, the contracts are governed by the Contract Act 2010. It's the parent act that guides us on how to contract, who can contract, the elements of a contract, and so forth. To go further, we have a variety of contracts, such as contracts that have to be in writing and then oral contracts. We shall see that under section 10 of the Contracts Act, subsection 5, 6, contracts that have to be in writing, we have the following. We have a contract of indemnity, a contract of guarantee, and a contract that is 50 currency points or above. Currency points in Uganda, a currency point is equivalent to 20,000 Uganda shillings. If we are 25 currency points, that's 500,000. So a contract that is 500,000 and above has to be put in writing. That means a contract below 25 currency points may not be in writing. That's at the option of the contracting parties. However, they can go further and put it in writing. That's if they wish so. After understanding that a contract is into two, it can either be oral or into writing, but it can be partly oral, partly written, whereby some conditions may be expressly into writing, whereas the others may not be put into writing. Who can contract? In Uganda, it's a person 18 years and above is the legal person who can contract. However, we have exceptional circumstances where a person below that age cannot contract. A person below 18 years can contract if he or she is under the guidance of an elder, let's say parent. You get, such a person can guide this person into contracting. Then after getting to know that it's a person of 18 years and above, we shall get to know that a person is able to contract when he or she is of sound mind. Why do we consider such things? The presumption is that a person of sound mind understands whatever he or she is contracting about. We have people who have lucid moments. We have people who can become partially mad, and at a point they do understand, at another point they don't understand. Such people can contract at the moment when they are understanding. You get, they can contract at the moment when their mind is completely working and completely okay. Then we have these ones who are totally mentally ill. Those ones can't contract at any one point because of course they don't understand anything. Then a person can also contract when that person is not barred or stopped by any law from contracting. Earlier on I said that a person below 18 years does not contract. That means the law forbids such a person from contracting. Therefore, they can't contract. However, you also have the mentally incapacitated persons. Also, the law forbids them from contracting. Then we have these people, the convicts. You get these people have served sentences who are found guilty of certain crimes, and also if it's in relationship with the contract, such people can't contract. Then how do people contract? Their minds have to meet. We will have what we call a consensus ad idem. It means meeting of the minds. That means these persons who are intending to contract have to agree. When you agree, that means the minds have met. Secondly, you shall get to understand that in contracting, the object on which you are contracting must be legally binding. You get it must be lawful, whereby let's say you can't contract on a stolen car. Reason being, it is illegal. Why is it illegal? It is unlawful to steal, because you also have an offense of theft. So we have such lawful. You get a lawful object. That means people can contract on only lawful objects, whereby let's say if it's land, all the documents supporting the existence of land, the owner, all have to be there. The other thing crucial in contracting is that these parties intending to contract must have a witness alongside them. Why? In case of breach, this person can testify that I was there and these were the terms and the conditions that applied. When we talk about breach of contract, you get a breach of contract is whereby one party violates the terms of the contract. Therefore, we go to the remedies that are granted when a person breaches a contract. We can have repudiation. We can have compensation. In compensation, there can be award of damages. You get. When I talk about repudiation, it simply means that a person backs out of the contract and he treats it as if it's not there. You get. When we talk about remedies granted after breach of contract, the main reason is to put this injured party in the position he or she would have been had he not entered into this contract. Therefore, among the remedies, we've seen damages. In damages, we have examples such as exemplary damages. These are awarded to ensure that this person acts as an example so that the others don't repeat it. Then we have nominal damages, we have special damages. These ones are specifically pleaded for. You present the receipts and so forth. That shows that you lost something. Then we also have, after seeing the specific damages and so forth, we also have another remedy, which is specific performance. This one demands that the person who breached the contract performs that act he or she had to perform. Let's say the contract was about buying a car, Mercedes Benz, and this person brought Ford. You get. The specific performance will demand that person to bring the Mercedes Benz, and once he brings the Mercedes Benz, the remedy would have been granted. Another point to note in a contract is after knowing that it is primarily governed by the Contracts Act, we have other acts that are guide on the same, such as Sale of Goods and Supply of Services Act. All those follow the Contract Act as the parent act. Who can contract? We saw that. Who can't contract? That person who is prevented by law, that person who is of unsound mind, and that person when the object the people are intending to contract about is unlawful, such as in theft and so forth. We have contingency contracts and so forth, but the primary points or the key points, we've looked at them, the elements that constitute a valid contract. One, of course, it has to be put into writing. That's if it's 50 currency points and above, if it's a contract of indemnity or contract of guarantee. Then we saw that those who can contract 18 years and above, then consideration